Good afternoon, everybody. Thank you very much for inviting me on this occasion to share my thoughts. And I'm duly privileged to be in the company of the two ladyships. The question that you have asked is about 498A. Please, let's understand one thing. These are all offenses against women arising out of marriage. So we have a civil part to it and we have a criminal part. So if there is a cruelty which is perpetrated on a woman, which is physical or mental, she also has a recourse to go to a family court and seek divorce on those grounds. But increasingly it was felt that that was not the only purpose, how cruelty should be treated by only giving a divorce. So in 1983, when these amendments were brought about, the idea was that the definition was expanded to include every kind of cruelty that can be meted upon her, not only by the husband, but by the relatives. And just for the purposes of, I mean, everybody knows the section by heart, but I'll just take a second and read it. That 498 says that whoever being the husband or the relative of the husband of the woman subjects such woman to cruelty shall be punished for an imprisonment, which may be a term extended to so on and so. The offense is cognizable. And the husband or the relative of the husband subjecting her to cruelty, subjects to such woman to cruelty, will be also imprisoned. So your question is very pertinent. The need for introduction of section 498A, as has been discussed by leadership and by my colleague here, arose from the offenses that were perpetrated on the woman, and whether there were dowry deaths or there was suicide, which was the outcome of the illegal demands from the husband and the family, and so on and so forth. And that is why a stringent provision was required. Now, all laws, with utmost respect, I would like to say, are made with a very avowed principle of doing justice to the larger section of the society, in this case, the women. But from the social point of view, that we found that out of 10 cases, and these are the statistics, and I'm just taking a sample, not giving you the exact statistical data, that out of 10 cases of 498A which came towards trial and a final order and judgment, it was only 2 or 3 that were really, the accused were held guilty and the others were dismissed. Now, there could be various reasons for it. Maybe there was lack of prosecutions, efforts to bring about the case, lack of evidence, the Panchnama and all the other prerequisites which are required were not in order. It could also be a case that was considered that it could be used as a false alarm, as they call it, a wolf case. And that is why I think somewhere down the line, there was a need to take a look at it in a very, what do I say, pragmatic and in a very rational manner. And that is why we had the Supreme Court judgment in Animesh Kumar, which has now laid down the rules, and they have laid down what should be done in a case where a 498A was there. I'm sure many of you practicing here would have realized that earlier there were cases where a complaint was filed, then लगेच नवऱ्याला, in-laws ना अटक करत होते. कधी-कधी आजी आजोबांना कोणीही घोषल्याचं विदाउट रिअलायझिंग की त्याचा इम्पॅक्ट काय होऊ शकतो त्या फॅमिलीवर. आणि ह्या सगळ्या केसेस जेव्हा वाढत गेल्या आणि जेव्हा लक्षात आलं की ह्या कायद्याचा काही सेक्शन ऑफ द सोसायटी दुरुपयोग करत आहे, तर ह्या गोष्टींचा देखील, बिकॉज शेवटी लॉ हा जेंडर न्यूट्रल असतो. देर आर स्पेशल provisions for the women, but law is neutral. It doesn't make a difference that if it's a man or a woman. आणि ह्या गोष्टी घेऊन अनिमेश कुमारचं जे जजमेंट आहे, and please permit me to read what the criteria was laid down, because that has now become a Bible in all police stations, or at least they're supposed to follow. I don't know. The ladyships may be having a different experience sitting on the bench. But what the court held was that the guidelines are, number one, that the state governments must instruct police officers against routine arrests under 498A unless the conditions laid down under section 41 of the CRPC were there. म्हणजे पहिले हा जो गैरप्रकार होत होता, तो तुम्ही कंप्लेंट आली आणि अरेस्ट करायचा, हे पोलीस ऑफिसर्सना सांगण्याची गरज आहे की हा रूटीन तुम्ही करू शकता. दुसरं, all police officers must be provided a checklist of the provisions of 41. That was more of procedural. The checklist must be filled up in the course of every such arrest, elucidating, म्हणजे giving in details the reasons and the material to support the arrest. की तुम्हाला जरी प्रायमा फेशी अरेस्ट करायचा जरी तो एक तुम्हाला ऑप्शन असेल, but that has to be application of mind. As the ladyship just said, you have to go through the facts of the case. understand whether there is any logic, any semblance of a crime that is likely to happen, and then they have to do it. Then magistrates must peruse the forwarded report and record their satisfaction mandatorily before giving the detention. So there is one more process, one more stage where this had to be done, where it really had to be gone into the details, whether an arrest was imminent. An FIR being lodged, process, investigation, nobody comes in the way of that. But the aftermath in some cases, which was, excruciatingly painful for certain families, that's where it came. And the decision not to arrest an accused with written reasons for the same should be forwarded to the magistrate within 2 weeks from the date of the institution of the case. Notice of appearance in terms of section 41A of CRPC should be served on the accused within 2 weeks from the date of the institution. The माझ्या experience मध्ये, of course, my experience in the criminal law is pretty limited as compared to all the dignitaries here on the dais, especially the Ladyship Justice Jadhav. But from what I understand, because I represent a lot of husbands in the cases, is that the moment a 41A notice comes, they are supposed to record the statement. But the immediate reaction of the husband and the family, and this I'm taking from a social point of view, not strictly legal, is that should I take a bail before I go to the police? Is there a possibility that when I go to the police station, you are telling me, ma'am, that you have to go and you have to record your statement and give the facts of the case? But is it a possibility that I can be arrested? And whether anticipatory bail has to be, the courts have to be approached for the anticipatory bail for the security and the protection. Now, these are the kind of things which I think my ladyship, with her wealth of wisdom and experience, will be able to tell us more of. But this is the fear, your ladyship, which is there in the minds of the husbands or the families who gets a particular thing. So I would really appreciate your views on this with your kind permission.
The case of Arnesh Kumar, the basic thing was, the courts had noticed that there was misuse of the provisions of 498A. Like so much that मुलाच्या मामाची कुणीतरी अजून, म्हणजे जे तुमच्या जवळ पण राहत नाही, किंवा मुलीची नणंद अगदी अमेरिकेत राहते, पण काय तर म्हणे सासूला शिकवते की माहेरी पाठवू नको. All this was taken into consideration. And so when they saw misuse of power, then Arnesh Kumar came, but that is mainly for arrest and for bail. It was so stringent that in clause 8, if I am not mistaken, the Supreme Court said in the operative order that even the magistrate who does not follow this procedure, then action should be taken against him also. This is because the members of that family would be exposed to social obloquy. बदनामी इतकी होते सोसायटीत, मग ते खरं खोटं कळेल म्हणजे इफ इट वॉज बीइंग यूज्ड ॲज अ टूल फॉर वेंजन्स, की आता बदला घ्यायचा आहे, मग वेगळं राहू देत नाहीत, मग चला 498A करा, हे जे सुरू झालं होतं, तर मेनली त्याच्यामुळे अर्नेश कुमार आलं. बट ॲज फार ॲज द केस कम्स टू ट्रायल, हे अरेस्ट आणि बेलसाठी बरोबर आहे की 41A आहे, त्यांना नोटीस द्या की तुमच्या विरुद्ध ही कंप्लेंट आहे. एवढंच काय तर महाराष्ट्र सरकारने एक सर्क्युलर काढलं आहे सगळ्या पोलीस स्टेशनसाठी की अशी जर कुठली तक्रार आली तर आधी त्याचं तुम्हाला त्यांची नाही इन्व्हेस्टिगेशन नाही, त्यांना समजावून सांगता येतं का बघा, काउन्सिलिंग, आणि जर होत असेल तर ऑफेन्स रजिस्टर करू नका. त्याच्यामुळे आता ह्या स्टेजला अजून एक सांगते, मुंबई हायकोर्ट हे पहिलं हायकोर्ट आहे देशातलं की जिथे आम्ही उपक्रम सुरू केला, चला बोलूया. तर त्याच्याप्रमाणे हे असे जेव्हा वाद निर्माण होतात तर पोलीस स्टेशनला गेलं तर दोघंही म्हणजे त्यांचं वाटोळच होतं, कारण ते अडकत जातात कोर्ट केसेसमध्ये. मग त्यामुळे कोर्टात जायच्या आधी आपण विचार करू आणि जर मिटत असेल तर मिटू, नाही तर वेगळे होऊ. ह्याच्यासाठी आम्ही ट्रेंड काउन्सिलर्स ठेवले. तर त्याच्यामुळे आपण हे सगळं सुरुवात केली. तर ते एक फार मोठं कॉन्ट्रीब्युशन आहे. जस्टिस ओक, जस्टिस डेरे, मी, आम्ही अगदी सुरुवातीपासून ह्याच्यासाठी, आणि ही संकल्पना त्यांची होती. तर हे सगळं केलं. अर्थात ते गव्हर्नमेंट GR आणि आम्ही म्हणायचे की पोलिसाचा खाक्या बघून तो प्रश्न मिटत नाही, वाढतो तो. कारण बाहेर आल्यावर परत भांडण सुरू होतं. मग त्याच्यामुळे आपण हा उपक्रम सुरू केला आहे.
अतिशय चांगला उपक्रम आहे, त्याचा निश्चितच फायदा समाजाला होईल. परंतु एक प्रॉब्लेम असा आहे की दरम्यानच्या काळामध्ये समजा ऑफेन्स रजिस्टर झालेला असेल आणि आता या चला बोलूया या माध्यमातून दोघांचं मिटलं, द केस स्टील रिमेन्स देअर बिकॉज इट ऑफेन्स इज नॉन कंपाऊंडेबल.
नाही, कंपाऊंडेबल नाही आहे. पण मग सेक्शन 482 खाली 482 खाली हायकोर्टाकडे खूप केसेस आहेत की जिथे बाय कन्सेंट तो FIRच क्रॅश होतो. आणि ह्याच्या पलीकडे जाऊन आम्ही सुकून म्हणून सुरू केलं की ज्याच्यात FIR क्वॅशिंगचा सल्ला दिलेला नसेल आणि केस पेंडिंग असेल, फॅमिली कोर्ट किंवा आणखीन कुठेही असेल, तर ते त्यांच्याकडे जाऊ शकतात काउन्सिलिंगसाठी. म्हणजे दॅट इज पोस्ट लिटिगेशन. आणि तिथे बरेचदा केसेस मिटलेले आहेत.
But so far as 482 is concerned, it's a quite an expensive job. So why not there be an amendment in CRPC to make it a compoundable with the permission of either court?
That is there. But that is again through 482.
482.
But now the time has come. Government is calling for amendments. You can suggest through your bar council.